the Justice for the Serlick Children podcast.
Good evening, everyone. It is Saturday, January 24th, 2026, and welcome to Season 2, Episode 2 of Justice for the Serlick Children podcast. Tonight, we're going to discuss all things Illinois District 2 Court of Appeals in my appellant brief. So, what was your thought on this whole thing?
I mean, so obviously we have some experience from you doing your appeals in Florida.
Right.
And the process, while there was some stuff that was similar, there was so many intricate technical rules.
Right.
And it certainly seemed like they were designed to prevent people from actually being able to get through the process.
Oh, absolutely. There are so many local rules. And then I also had to navigate my sitting judge in Illinois Circuit 19's courtroom rules, which I guess requires you to send certified copies of your notice of appeal directly to that judge, et cetera.
Yeah, but when you try to file the courtesy copies, they just keep kicking stuff back.
They
to you,
reject the emails.
And then they just they say, please reference rule, the local standing order or something like that.
They just say reference the standing order for courtroom 105.
They don't say what the issue is at all. It's just, and I think we both lost track of how many times you were trying to submit stuff.
Yeah, they keep getting pushed back, rejected, emails with vague responses saying, please see standing order. So when you have, I'm going to put this down. When you have a final appealable order in a lower tribunal, so family court, you can file a notice of appeal. Typically, that's within 30 days. Or if your state has an accelerated notice of appeal, like Illinois does when it comes to custodial for children, you have to get it filed within 14 days, which I did. I filed my notice of appeal within that 14-day window. So depending on your specific state, you may have less than 30 days. So you need to definitely research all of this ahead of time so you don't lose that opportunity to file that notice of appeal because what Judge Melius did was she filed a dismissal with prejudice, which meant that ended.
You would never be able to file a motion to vacate again.
Right. No petition for relief and vacature under that specific Illinois statute because she dismissed it with prejudice, which means the only alternative is notice of appeal. And if you miss that appeal time, you basically lost your only shot.
So before we get too deep into this, I do want to put out this disclaimer. Neither of us are lawyers. We are not giving legal advice. Nope. We are just talking about our experience
as pro se.
In Heather's pro se litigant status representing herself in her court cases.
Right.
So with that being said, I also think it's important to let people know if you're in family court and you are representing yourself, even if you don't necessarily think you're going to have to go to appeals, you need to be researching the process and the steps now. Even if you're just starting in family court, you need to be ready because, as Heather said, there are time limits and restrictions on when you have to file stuff if you're going to appeal a judge's decision. And we'll get into that, what makes a decision by a judge that can be appealed.
Yeah. So temporary orders that are not final are non-appealable. So you need to understand the difference between a temporary order and a final order.
And this is something a lot of people in family court run headfirst into because the family court judges have learned that they can get away.
They can play this game with the temporary orders.
Absolutely zero oversight by just making everything a temporary order.
Yep. And it's happening all over the country, not just Illinois, not just Florida.
This custody order is temporary until the children are 35 years old.
Mm-hmm. In fact, a friend of mine is up in Canada, and he has a very similar temporary order.
Same 3 pages. Very similar. He shared his screen in Zoom, showed me his order, and I said,
let me share my screen and show you mine. And it was kind of shocking to see that between the U.S. and Canada, we are both dealing with very similar temporary orders that our ex is hiding children behind. Yeah. So even not in the U.S., this is a problem.
Now, in your case, I mean, we're going to get into some details about your case, but as we're talking about the process of appealing and the timeline to appeal, when this order in question was first signed by the judge back in 2022, you did not appeal.
No, because, well, first of all, I had no clue that order existed until almost 3 months later when my ex-mother-in-law, Mary Serlick, emailed it to me it was like June 19th of 2022.
So that was after the time period had expired.
Right. And with it being a temporary order where it reserve, I mean, that is a key word right there. If the word reserve is anywhere in these orders, that literally makes it temporary. Yeah. It means, by legal definition, means that a judge needs to hear that portion of the order at a later time. Yeah, it's reserving it for a later time. So thus temporary. Just
to clarify, and I mean, this is sort of, I mean, this may be in every state, but, you know, related to a custody order, you know, this order in question, it reserved your rights, your parental rights to your own children.
To my 3 children that were being shipped down to Illinois, and then reserved Ariana to Justin and I both.
So that made it
2 separate
reservations.
Temporaries. Yeah.
Yeah. So that made it technically a temporary order, but for that to have been a permanent order, it would not have left you with your rights being reserved. Right. It would have been your rights as a parent have been terminated.
Exactly.
And then that would have been a permanent order.
Right. And that's considered a TPR, but there has to be a actual trial and everything.
In your case,
there was none of that.
In your case, so we know the Illinois order was temporary, so you couldn't have even appealed it if you wanted to. So you were limited to requesting it to be vacated, and you had like 30 days to do that.
So that means that I would have had to have been sent it. It should have been sent to me by Illinois Circuit 19 and Justin's attorney at Katz Goldstein Warren by within a few days of the April 27, 2022 signing, which means that I should have had the opportunity to motion to vacate it in Illinois Circuit 19 by May 27th, 2022. And I had no clue it existed until like June 19th, 2022, when Mary Serlick emailed it to me gloating that I lost custody of my kids when in reality it was reserved.
That email she sent you is really sadistic.
It is.
Now I will. I'm curious because again we've sort of established that technically by the wording of the order it was a temporary order.
Right.
Now everybody, by the time that was signed off, everybody was living in Florida, and we'll get into the details
except
there.
Ariana. Everyone but Ariana.
But when you opened your case here in Florida, Justin's attorney argued that it was not a temporary order, that it was a final permanent order.
Yep. Because they thought that I was too stupid to know any better. And they're obviously, these attorneys and judges are obviously used to uneducated citizens that, they can play this game with. And I fortunately am educated and know what the word reserved means.
Yeah. And
so when I pointed out to Serena Baldacchino, I said, no, it literally says reserved. Not just once, but twice. The word reserved is in that 3-page order.
Meaning the court didn't make a decision on those aspects, and they were going to have to make a decision at a later date. But as we have found out, the court here in Florida is basically, I mean, it's family court in general is a court of no authority, meaning nobody wants to take authority or responsibility. Call it a court of no responsibility.
Right.
Judges don't want to take responsibility.
Ruining lives and not taking responsibility.
Attorneys don't want to take responsibility, but they certainly want to blame people.
Yeah.
Now, getting back to the process, because I don't want to get sidetracked on, we'll get to your case.
So
you've got a couple books there on the desk.
I do.
Slide them over here so people can sort of see.
I do. So I have 2 books. One is not very thick. It's thin. And then one is this thick.
Now you had those bound.
Yes.
They didn't come that way.
No. So you get these off of every state's court website. There will always be a section for pro se litigants. So I went on Illinois Supreme Court's website as well as Illinois District 2 Court of Appeals website and pulled any and all pro se resources available to me. So that was the very first thing I did. Now, this thinner book is actually a combination of several different documents meant for pro se litigants. And then this thicker one is literally just one book called a manual, a guide to Illinois civil appellate procedure, and it's written specifically for pro se litigants. Yeah. And the back has a very useful section of like just samples of how each different motion and filing should look. It's John Doe versus Acme Manufacturing. So fictitious court orders to show you how it should look as a pro se litigant. And this has been incredibly useful.
I was going to say, we would not have been able to get everything done without these books.
No. And this thinner book, I actually took one guide is just on like all the different steps. So step 1, file notice of appeal. And then it literally walks you through the deadlines, how early you have. So like cases with shorter deadlines, you may file a shorter deadline for filing your appeal if your appeal involves certain orders made before the case is finally resolved involving custody or care of children 14 days. Now, here it is saying right here, I've only got 14 days to file a notice of appeal, even though everything else is 30 days.
Now, we mentioned that a lot of these rules are so super technical and they're designed to get people to fail the process. In that handbook there, does it mention anything about having to notify the presiding judge and the chief judge of your notice of appeal?
No, but these are the rules for the notice of appeal. What you're referring to is a local rule at Illinois Circuit 19.
No, that one wasn't a local rule. That was, she cited that it was under an Illinois Supreme Court rule because of the expedited status of the case. Yeah. But regardless, I mean, so we ran into that.
We had to navigate that. But this portion of the guide that I put together with some others, step 1, step 2A, step 2B, step 3, filing the docketing statement. Step 4, filing the appellant's brief. Step 5, file the appellee's brief, which is the other party. Step 6, file the appellant's reply brief, which is me again. And then step 7, appellant court's decision. So it literally, in layman terms, breaks everything down on how to do it as a pro se litigant.
Now, I will say that Illinois had this, you got similar manuals from Florida, but it wasn't as
detailed. Yeah. So even though Illinois does have more technical rules and procedures you have to follow, I can say, at least for me, it was very easy to follow the steps based on how this was written out and step 1, step 2, step 3. I think in that format, so it was very easy. And then I even have a checklist for filing, so you can check it off after you do it, so you know where you're at in the process. And then pro se notice of appeal, it tells you the costs involved. And then here's another one, how to file a notice of appeal, civil, and each section tells you what section of the appellant brief should be about.
Even when you're representing yourself, some of this stuff costs money. Yeah. So you've had to pay for a few filings. You had to pay for your record.
In total, for this Illinois district,
$500 or $600.
About $5. Yeah, because just
postage was $100.
The record. Well, we're going to get to that. The postage, because that is its own special rule for a local rule for Illinois District 2 Court of Appeals. Yeah. So not every appellant court in the state of Illinois might have this rule, but I can tell you for District 2, they do. So I also went to District 2 Court of Appeals website, and we'll bring the websites up just so you can see what they look like in a minute. But I even printed the local rules, and one of the local rules, just so you can see what I'm talking about here and why we had to ship stuff to them, we are required to give Illinois District 2 Court of Appeals 5 physical copies of the appellant brief and the appendix, and it has to be there within 5 days of you filing your appellant brief. Now,
and it doesn't specify business days.
No,
it just says 5 days.
Just 5 days. So, but and you also have to have them bound, so they have to be stapled or spiraled some way to keep them all together, so it's easy. So 3 go to the panel of judges, 3 justices, and then 2 go to the assistants that help research for the judges. So 5 total physical copies have to be physically mailed or dropped off if you're local to Elgin, Illinois. So for me, mailing those 5 copies cost me $100. Now, luckily, I was able to get the appendix waived, and I'll get into that in just a second. But I want to share a screen so you can see what these 2 websites look like where I got all this documentation from.
First one up, we have the 2nd District Court of Appeal. So this is off the Illinois Court's website. They have separate subsites for each appellate court.
Yeah, for each district. And so I'm out of Elgin, which is Kane County.
And so if you go to the Illinois Court's website, find the 2nd District Court of Appeals, and you'll see here 2nd District local rules.
Yep.
So it's important, whatever district you're filing into, make sure you find the local rules. Now, in this case, it's just a PDF document, but some of these apply, some of them don't. Some of them are just procedural issues. But you definitely want to make sure
you have to read through all of this before you even get started. You need to know what you're looking at.
We didn't necessarily know about the 5 physical copies rule, but you happened to be. You had a separate question. You called the clerk's office on how to file something or how to do something, and the clerk you were speaking to mentioned sending 5 copies, and you're like, wait a second, can you explain that a little bit more? And they said, well, go here and look at these rules.
Right. Yeah. So because I've been building up my lower tribunal, Illinois Circuit 19 docket, getting as much on the record as possible, knowing that my goal was to get this into appellant court. Like, I had this all mapped out and planned out in my head a year ago. So I knew quite a while ago this was my intentional plan if things didn't work out here in Florida Circuit 7.
And there was it was a specific one night where this whole course kind of got set in motion.
Yeah. And really what got us considering this was we were in a Zoom with a friend of mine across the other side of the country, Beth, that was explaining UCCJEA. She's an expert in that because she's dealing with her own UCCJEA situation with her child.
Yeah, so she had you pull up your docket and share your screen, and she was looking at it, and she's like, wait a second. That's missing.
Yeah, you have jurisdictional issues.
And we started looking at it and then trying, just putting filings on a calendar and sort of seeing how things overlapped. And all of a sudden, like, all these red flags were just like waving like crazy.
So talking to others and sharing your case with others really helps you kind of see the bigger picture that maybe you're missing. And everyone thinks differently. Like, I think very analytically, but someone might read something differently than I do, and then they can point out something that I'd be missing. So I would say absolutely meet up with someone that you trust in a Zoom, have them look at your documents and see if they can see something that you can't. Yeah. Because that's how I figured out this path.
Yeah, because before we had that Zoom with Beth, really, you were going down the path of trying to get the local court here in Florida to just modify.
Yeah, and they just kept saying, you haven't met the change in circumstance. What are you talking about? Like, there have been so many significant changes that I have a whole plethora of significant changes.
But they're not significant enough.
That's
is what they like to say.
BS excuse for not changing these temporary orders
because they don't want to take responsibility.
Right. And it's very clearly already decided what the purpose of that temporary order is, which is to hide children behind them. So why would they want to modify what they already knew the purpose of it was?
Ultimately, after meeting with Beth, we started doing a lot more research on our own, researching a lot more about the actual law, the UCCJEA. And then, beyond that, we find out there's other similar laws, UIFSA, and then, then there's all the other due process
Can you
stuff.
bring up this is part of Illinois Supreme Court's website, because I've had a lot of people asking me.
Statewide forms?
Yes.
Okay.
I've had a lot of people asking me for samples of how to format in Illinois. And I want everyone to know that if you are just not savvy with writing. Not all of us are writers, and that's okay. If you are not good at writing or formatting technical forms, no fear. Illinois courts, and not all states may have this, but Illinois does. If you go to illinoiscourts.gov.
This is the main Illinois courts website. All you have to do, hover your mouse over the forms tab.
And then go all the way to the left.
To the left, top of the column, approved statewide forms.
Mm-hmm. And then scroll down a little bit.
Bring you here.
And you're going to see the 3 different courts.
Now, this may even be useful for some folks who are still in circuit court.
Yeah.
There's some forms here that you can pull up and use.
Child support modification. So
on the middle tab is appellate court tab,
which is where I'm at right now. And then if I don't get anywhere with District 2, Supreme Court is next in Illinois.
We'll go. I mean, because we wanted to cover the process here a
Right.
little bit. So the very first part of the process, once you have a final unappealable order,
you get that notice of appeal.
So it's actually pretty easy. You go right here, the notice of appeal.
Now, I want to point out this Start Easy form. This is broken down even into easier steps. However, I myself have noticed bugs in the software. I'm very software savvy. One of my jobs previously was literally to break a software and report it to DevOps before they release the software to the general public. So I've found bugs with the Start Easy form. You'll type something because it'll literally ask you a bunch of questions. You'll answer it, and then it'll put your answers pre-filled out in the form, and all you have to do is fill out the form. Sometimes this Start Easy website doesn't put all the information in, so you have to be very careful and read over it before you e-file it because it sometimes is buggy.
So if you skip the Start Easy form button, if you come down a little bit further, they actually do have fillable PDFs.
Now, the Getting Started and the How to File, those both have been printed and are in this small book. So that's where I got those.
You literally, it says Getting Started, start there, read those documents, read the How to File a Notice of Appeal, and then you get to the Notice of Appeal. When you click on it, again, at fillable PDF, you literally just fill out the district you're filing into. So you do have to look that up to figure out where you would be filing. I recommend looking up how to fill, how your case is supposed to be worded or named. It's
and
not
then
necessarily
the left side,
a direct copy.
And this is the exact form I used for my Notice of Appeal. Mm-hmm. The left side actually has directions on exactly what you're supposed to put in every fillable box. Yep. And then my situation, if you look at the very top, this appeal involves a matter subject to expedited disposition under Rule 311A. That is my situation with custody and care of my minor children, so I had to check that box. That tells the appellate court it's expedited. That tells the circuit court it's expedited.
Which, again, getting into those little technical rules, anybody that's appealing a child custody case in the state of Illinois, even if you're not using the approved forms, you are required to have this statement in bold, all caps, at the top of the filing of every document you file.
If it's not on there, they don't know it's expedited, and it could screw up the whole appellant case.
So, but again, this is pretty straightforward. You just fill in the information, the Notice of Appeal. You're not getting into any of the arguments. It's literally just telling the court, hey, I want this order appealed.
Yeah.
And then it's
pretty simple.
You do have to attach a copy of the order.
Right.
So you can't just
fill
this in, print it, and email it in.
And it literally, like I said, on the left side, layman's terms, you do not have to, even have an associate degree to understand this. It's very, very basic information. And then you file that Notice of Appeal, and then once it is actually processed on the circuit side, because you have to file this into the circuit court, and then they communicate to the appellant court, and then the appellant court processes a letter and then sends a letter to you. And then, unlike Florida, it was my job to send that notice of filing to my ex-husband. So Florida automatically sends it out to both parties. Illinois does not. You're responsible for sending out that letter with the case information to the other party. So what that triggers eventually is you'll get a big letter in the mail, and this letter is your index to your record on appeal. So common law record table of contents. So you need this in order to write your appellant brief because you have to reference the page numbers of the appellant brief in the appellant brief, and then you also have to attach all of it to
so
your...
one of the important things to recognize when you do appeal, and this is sort of universal probably across most appellate courts, is you can't introduce new evidence.
Nope.
You can't walk into the appellate court and say, look at these emails I just found.
It's got to be in the common law record in the lower tribunal.
So this is why it's important in your lower court
to document everything.
Even if you're not getting motions decided in your favor, you still want to be filing. And again, this is not legal advice, but you want to be at least filing stuff into the docket. Whether
constitutional challenges, if you
even just filing your evidence in,
right?
I mean, so you can file. I mean, there's different ways to do it, and again, I don't want to get into where we might be construed as giving legal advice. But
I've been, for me personally, between Illinois Circuit 19 and Florida Circuit 7, I have been filing some pretty. How do I want to say it?
Voluminous,
not normal.
Okay. Yeah.
Filings that you would see if you had an attorney. Like I am filing notice of constitutional violations, notice of docket manipulation and showing the evidence and
notice
pointing
of judicial misconduct.
Right. Yep. So I'm literally calling out everyone that is harming and abusing me in these court systems by name because I am building a much larger case for federal court.
And because you have filed all that information with, and sometimes it's included with, the sort of it's with the evidence of the other motions you're filing. Sometimes it's standalone filings just to get it on the record. But because you did all of that, you were able to have a pretty voluminous record on appeal where you could actually cite stuff. And,
exactly. And that was my intent the whole time. I had this all planned out a year in advance. So I do want to, we have quite a few comments.
Okay.
So Phil said, why do they require 5 copies? Who gets each of the 5 copies? So 3 copies to the 3 justices on the panel, and then 2 copies for the researchers that help the justices. And then Tom,
and that's just a personal preference of the judges in that district.
That
they
is
like
a
to
local
have
rule.
the physical copies. Now we'll get into the difference between the brief and the appendix. And in Heather's situation, she actually got permission to do.
We'll move on to that in a second.
Different.
But those 5 copies are a local rule for Illinois District 2 Court of Appeals. It may not be the rule for all the other districts, but those justices, I guess, prefer to read a physical piece of paper, and I don't blame them. After being in corporate America for over 15 years and staring at 4 monitors at my cubicle for 14 years, my eyes don't do well reading documents in length physically on the screen, so I print things and read it. And then we have Tom. Family court is making more lawless sense considering ICE and kidnapping, aka family court trafficking. Yep, that's what we're all exposing and whistleblowing. As soon as we speak up and expose their crimes, we become targeted. Yes, we do. Absolutely. Do you know anyone who's gone on a podcast and gotten their kids back? So here's the thing. This current movement of everyone exposing what's happening in family court is new.
I was going to say, this is sort of the
We're all part of this new movement.
Time, technology, social media, it's all coming together, and the court system and the judges honestly are not ready.
No,
for
they
this, which
are
is good
not.
For the pro
That's
se,
good for us.
pro se litigants.
Christine Miller and Hugh Barrow from the Judgmental podcast through Louisville, Kentucky. They are absolutely getting some blowback from them whistleblowing their own previous colleagues.
They literally there was a guardian ad litem in the Louisville area that filed to recuse herself from a case and cited their podcast and the information it was putting out.
So would I say it's helping people at this very moment? I don't know. There are so many of us across the nation. I don't know what success stories we can really brag about. However, It's only a matter of time. The louder we get as citizens to what these state actors are doing to our families, the harder it's going to be for them to continue doing this in the dark, because we have technology, social media, and AI now, which never existed before. So this is new territory for all of us.
And while it's new territory for us, I do also just want to put it out there. Obviously, everybody out there may be in a slightly different situation.
Right.
The reality is Heather's in a situation, and the reason some of the stuff she has filed, the reason why she has filed it, she's really at a point of...
There's nothing left for me to do except just expose all of it. They've taken everything from me.
There's nothing left other than to be vocal, put the story out there as many places as possible, put the documents out there to show the truth behind them.
Now, if you still have your children and you're going through a nasty divorce and you're concerned about you losing your children,
you don't want to be putting everything
then
online.
You might want to think twice about getting loud. But if your children have been kidnapped, given to the abuser, and you've got nothing left to lose except your life and your freedom, what else do you have? So you start exposing. So that's what I started doing. Let's see. Now his next question was... the appellant division has amazing caseworkers to help. Yep. I don't have many complaints about Illinois District 2 Court of Appeals at this time.
And I will say, noticeable difference between the circuit courts and the appellate courts when you call the clerk's office. Not to get assistance in your legal standing, but literally just to assistance in the technical process of stuff.
Like their local rules and stuff.
Night and day difference.
Answer my questions without transferring me 15 times. Illinois Circuit 19, Aaron Cartwright Weinstein as the clerk of Illinois Circuit 19, Lake County, Illinois. She's running a shady clerk's office. They are absolutely manipulating my docket, and they are absolutely purposely transferring me around when I have a question to not answer my question. And it just pisses me off to the point where I go to Aaron Cartwright Weinstein and report her clerks and what they're doing to me, and then shit actually gets done.
Sometimes it is all about who you know. And
now,
that's part of the problem.
Now, then Tom said, not if you're labeled vexatious litigant. You can't just file.
Not every state has a vexation litigant law.
Florida just passed one in 2025.
But there are certain things that trigger that. And so, that is something people do have to be careful about. We don't want to get into the details on what causes that, because honestly, we know Florida just passed a law, but we haven't dug too deeply into it. Yeah,
I do know someone here in Florida that has been labeled a vexatious litigant, and she cannot file anywhere, and hopefully she takes that to federal court.
Yeah.
Then he said, you're being retaliated against, and who knows when it stops. Yeah, so, I mean, obviously... our country has whistleblower protections for a reason, right? We're targeted the moment we start whistleblowing. So that has to be something that you are willing to take the risk on. For me, all I have left is my life and my freedom. So it's a risk I'm willing to take to make sure that my 4 children know the actual truth and know what's actually going on. Because otherwise, I just sit here in silence and nobody knows what happened to my children and I, which is what the Serlicks want. And everyone that helped them is what they want, is for me to just disappear and die already, which is something that's consistently said to me. So you have to understand that the moment you make the decision to go public and whistleblow, you are going to be subjected to retaliation. And that needs to be something that you make the conscious decision that you're willing to take. So it's an individual choice you make. And this is the choice I made. And I hope others are as bold and courageous as myself and others that are whistleblowing. Because if we don't get enough people getting loud about this, it's just going to get buried. Yeah. It's just going to get buried. So we have to have enough people that are willing to take that stance.
Just pulling us back here to, real quick, because I know there's a bunch of comments, but we again, first part of our episode tonight, we wanted to go over some of the technical filings. So last part of the technical, let's cover the timelines a little bit. Yeah. Because those are critical.
Well, so my timelines are different than a normal timeline because, like, for example, the notice of appeal, all other appeals have 30 days to file that notice. because my situation has to do with care and custody of minor children, it's expedited, so I only had 14 days. So that's why you have to know these rules ahead of time, and that's why we're doing this episode, just to educate you guys on how to know your local rules, your state rules.
We're just trying to put out there some of the stuff.
And that's why lawyers get paid so much. They have to know the rules.
Yeah, we're just putting this information out there. This is stuff that we came across in our, process of going through this. So we just want to put the information out there so people are aware.
I'm an educator. I'm a public school teacher. Right. I educate. So that's what I'm doing right now. I'm educating.
What do you got there?
Okay. So after I filed the notice of appeal and I got this packet in the mail with my index, I then filed, after learning about these local rules, I then filed 2 motions directly into District 2 Court of Appeals. And the first one, and I filed these both at the same time, was motion for leave to waive the requirement of 5 paper copies. So I'm all the way in Florida. It costs money to ship all this stuff. I'm not local to Illinois where I can just drop it off. So I had filed to waive the requirement of all the physical copies of the brief, the appellant brief, and the appendix. My appendix, you'll see in a minute, is over 600 pages.
If you don't ask, the answer's no.
Yep.
And you got an answer back that was okay partly.
Yep. So I filed that, and then at the same time, I also filed a motion for leave to exceed page limit of appellant's brief, because I wanted to make sure, because this involves 5 now 6 years, because we're in January 2026, 6 years of this insanity that has not been able to get into appellant court yet. So obviously I have a lot to write. And I also wanted to make sure I got everything in my appellant brief I wanted to get. So in the event I went beyond the 50-page limit or 15,000 word limit, I had this pre-approved to go past that limit.
And that's something important to know. If you are not sure, but you think you might be going over a limit, you do not want to be filing that on the day your filing is due.
Nope. You got to be prepared to get that
proactive, get it filed early. It's always better to ask for permission to get more pages or more word count than to get to the day you're needing to file and you have to start deleting stuff.
Right. So I wanted to make sure I had all of my ducks in a row so I could do what I truly wanted to do. And like I said, if you do not ask, the answer is no. So what is it going to hurt? The worst they're going to say is no, but at least you asked, right? So I filed these 2. What was the date on it?
I don't remember, but your worst case scenario was you were going to pay a lot of money to print and ship a lot of paper to Illinois. 5
copies of the appellant brief and 5 copies of my appendix that goes with the appellant brief.
The appellant brief was 70 pages or so, and the appendix
is over 600.
10 times that.
Yeah, it's over 600 pages. It's like
so
684 pages.
We're literally talking about a full case of paper being shipped.
So the date is not on here, but anyways, so I got a pretty quick response about a week and a half later. So January 12th, I get a response back from Illinois Appellate Court 2nd District. The court has this day, January 12th, entered the following order in the above entitled case. Appellant's motion for leave to file a brief in excess of the page limit is granted, and the brief is hereby filed. So actually, the day he pushed this through is the day I filed it. Yeah. So, and I actually was able to surprisingly get everything I wanted said in my appellant brief without going beyond that. So
within the word count. We were over the pages.
I was over the page limit, but I could.
And the rule is either or.
Right. So I went over the 50 pages, but as long as you stay within that 15,000 words, you don't have to worry about this. But I was concerned that I might go over, so I asked. The answer was yes, and then I didn't need it after all, but the answer was yes. And then next, appellant's motion to waive this court's paper copy requirement is granted only in part. As appellant has not obtained a waiver of fees under Rule 313, appellant shall provide paper copies of the brief instead, but need not include paper copies of the appendix. So as soon as the clerk's office found out that my appendix was 600 something pages, they're like, God, no.
They're like, we don't want
We
this
don't
either.
want that.
And-
We don't want that shipped to us. We got to lift up the box.
And yes, Willow, our cat, wanted to make an appearance on the podcast.
Yeah. So it worked out. I had to mail 5 copies of my appellant brief, which was like 71 pages in total. But I did not have to file or mail the 5 copies of the appendix, which was 600 pages each. So that all worked out. I was happy with that. So far, so good.
So now you've got all your stuff filed in the appellate court.
I filed on January 12th
now it's
my
a waiting
brief.
game.
So this is my brief. It is in total, I believe, 70 something pages or
70
something
or
like
72.
that. Now, when it comes to appellant briefs, really only a section of the appellant brief falls under that page limit.
Yes.
Your cover page, your table of contents.
Yeah, so there's, for anybody
your
who's...
points of authorities.
Yeah, so
none of that counts.
For anybody that's new to actually drafting and writing an appellate brief, there are required sections. So you need to check with your state to find out what's required.
Right. Every state
so
is
there's
different.
A lot of these pages are just, required formatting things
Mm-hmm.
to put out some information. And then, others are, critical for the,
Yeah. So this is my appellant brief. Let me get it over here so you can see, it's quite big. Not too bad though. For me, this is nothing. I've written research papers bigger than this. So for me, this is nothing. I'm a writer, so it's easy for me, but I can understand how it might not be easy for others.
Depending on the circumstances of your case and what you're appealing and how many arguments you're raising, your briefs are going to be different lengths. So don't think just because you see what Heather filed that you need to have the same. You may not need the same.
Right.
But there was a lot of...
My case is there's a lot of working parts to it. There's a lot of people involved.
Not only does your case basically have you appealing an order, but you're appealing an order where you were asking the court to review a prior order.
Right.
So now you're asking the appellate court to also review that prior order. And then in researching and getting your appellate brief ready, we realized there were so many due process critical a lawyer would call them a fatal error, but so many of them in your case that it just necessitated us bringing them up.
Yeah.
Because the other important factor is if you don't bring up the argument in your appellate brief, you don't get to argue it. You don't get to argue it later on. You don't get to go to the Supreme Court and argue a point that you didn't bring up in your appellate brief.
Yeah. So Tom is asking, how do I know when to file a brief? Well, first of all, you have to file that notice of appeal. You have to have a final appealable order in the lower tribunal family court in order to file an appeal on an order.
And
so
you
in
have
my
to check
case,
with your local state rules.
Right. In my case, I had my petition for relief and vacatur in Illinois Circuit 19 dismissed with prejudice. So that made it a final appealable order. So within my time frame of 14 days, I filed that notice of appeal. And that got the ball rolling in Illinois District 2 Court of Appeals. And then they send a letter in the mail telling you when your appellant brief is due. In my case, there's also a docketing statement. So Illinois specifically has a lot of technical things you have to file before you even get to that point. And that's all in that manual that I was just explaining.
Now, along with your brief, you have this whole other tree worth of paper on this desk. You're going to break the table in front of us, probably.
I'm going to scoot it over because it's too big and I don't want to.
700 plus pages almost.
Trying to get it all on the camera here.
So what this is, folks, this is the appendix for Heather's appellate brief.
All this.
So
all of this. And
Heather,
I'm going to tell you, most of this is my filings into the...
what on earth is an appellant brief appendix and what is it for?
So you've got the record on appeal that the tribunal court is responsible for sending over, but you got to pay for it. So I paid almost $400 for my record, so my actual entire Illinois Circuit 19 record, to be electronically sent to Illinois 2 District Court of Appeals.
Basically every document that's in the docket.
Yep.
In order.
Yep.
With a
and that's,
table of contents that the clerk prepares.
Right, and that's what that letter is
sent
that I got
over
in the mail.
as a massive PDF file.
And it's electronic. So what the appendix is is you putting together any relevant documents in that record on appeal that you want to raise in your brief.
And it's
So
really
this is
it's
all
more of a
for my argument in my brief. This is all documents that I
and
referenced.
this is more of a quick reference to the evidentiary documents for the appellate judges.
So they can just quickly go through it. Now, this is, as you can see, how big it is. If you are listening to this on audio only, like Spotify or Audible,
that's got to be a stack of paper, probably 4 to 5 inches tall.
it's probably 5. It's almost
I could
700.
make a joke about it being 8 inches, but I won't.
Yeah. So obviously, can you imagine me having to send 5 of these along with 5 of the appellant
I mean,
briefs?
your appendix is more than one. To give some people a
It's
context,
more than one
it's more
ream
than
of
one
paper.
ream of paper. So
'Cause
if
that's
you
500.
have a package of paper, that's 500 sheets of printer paper.
Yeah, this
and
is almost
more
2
than
reams
that.
of paper right here. And this is all common law record from Illinois Circuit 19, so the lower tribunal. And this was all in my docket before I started my notice of appeal. So
Now,
this is what I'm
one of
saying.
the-
You have to make sure that you are documenting everything in your lower tribunal case first.
One of the, just on here's a technical thing too. In the process of working through your court stuff, we realized early on that it was going to be a massive benefit to have a serious laser printer
Yes.
and a serious high-speed scanner. Now, obviously, we understand not everybody can afford that
Right.
stuff. We were fortunate enough to be able to have those available to us.
Yeah, I last year when I was really going balls to the walls with Florida Circuit 7, I had bought a cheap scanner off of Amazon. It was a Chinese knockoff.
It worked for like the first 25 pages,
It was
and then it
horrible.
was a nightmare.
So ultimately, I broke down and bought myself a nice Epson scanner from Office Depot. And it has been a workhorse.
It's a high-speed, double-sided scanner.
Takes 50 pages at once.
50 pages in the feeder.
Scans it,
scan
pops up on the software.
You put
It
another
has
50
been-
pages in, and it adds it to the document.
It has been a lifesaver because remember, once you put this together, you then have to scan it all and then scan it as a PDF to eFile
So
it.
if you don't have that, you're running to Office Depot and hoping there's not a line of people.
Yeah.
and
So
hoping they can
if
help
you are going to get serious about fighting this system, you're going to have to do some investments on some good electronics to help you.
Yeah, you want to have a real computer. Don't try to do this stuff on your phone.
Yeah, do not try to do this stuff on your phone. I can't believe people are
real-
actually doing this on their phone. I could
real
never.
quality printer, and it certainly helps to have the high speed scanner. Now, you can get a multifunction, printer that has a scanner tray. It'll do the job. It'll take some longer time.
So Tom is saying, is that what they mean by transcripts? No. So transcripts is all the recordings from the lower tribunal and the common law record. In my case, I have absolutely no transcripts
there's
other than
your original
my
divorce.
original divorce hearing on June 24th, 2013.
Think of it like this: the transcripts. If there's a court reporter with the
Typing.
stenographer,
Yeah.
the stenography machine,
That's a transcript.
that produces the official transcript.
If they actually record your Zooms or however you guys do virtual
Then
meetings,
if there's an official video or audio recording,
you can get that, and then
But
you have to pay someone to transcribe it for you.
third-party transcription companies.
That's
and
the RICO.
They are not cheap.
that's the RICO.
One thing we've run into here in Florida, the one company that is the only one approved by the clerk of the court, you call them up and say, hey, I need you to come to a hearing. They say, are you self-represented? And you say yes. And they say, oh, I'm sorry. We don't work with pro se litigants.
Yeah, we only work with attorneys.
So
Yeah. So the brief and my massive appendix were e-filed on Monday the 12th, January 12th, which was when mine was due. And then right after that, the very next day, I had mailed out those 5 spiral bounds. So to keep everything on the record, because I'm all about making sure everything is documented, because in my situation, I have been building a federal civil rights complaint case since all this began October 8th, 2020. So I want everything to be on the record and documented of what's going on, because that is all going to be evidence in my federal case. So after I mailed out the 5 copies of the appellant brief to Illinois District 2 Court of Appeals in Elgin, Illinois, and then 1 copy of the appellant brief to Justin Serlick, my ex-husband, I then filled out a correspondence and then e-filed that into Illinois 2nd District. So it's literally correspondence. Now remember, all of these documents will be Google Doc links once I post this. Yeah. All of this will be scanned with my awesome scanner and then put into a Google Doc link, so you can look at all of this documentation as you're listening to this.
Feel free to use it as educational material. Obviously, we can't guarantee that what we have in our documents is going to be what you need for your situation.
It's a good guide, though,
but
because I'm at least the
certainly
stuff
it's information that's not going to hurt you if you take a look at it.
Yeah, it's getting accepted. So obviously, I'm doing something right. I'm not getting kickbacks constantly, so I'm doing something right with the formatting, etc. But again, I'm not an attorney. I'm just a mom fighting for my children pro se, because I've had multiple attorneys steal $66,000 from me since this crap began in 2020.
Now, the correspondence that you filed, it was basically just doing what?
Yeah. So correspondence, please take notice that on this 13th day of January 2026, the undersigned has mailed the following documents to the clerk of the appellant court, 2nd District, and appellee Justin Serlick via USPS. 5 spiral-bound copies of the appellant brief with the attached tracking number, blah, 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 and should arrive by Friday, January 16th, 2026. 1 copy of the appellant brief to appellee Justin Serlick with the attached tracking number, blah, 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 to his home address of 333 Landfield Avenue, Daytona Beach, Florida, 321. I did it again. Oh. I keep putting our zip code. Oh, the appellant brief, as well as the appendix of 673 pages, was directly emailed to him, as well as e-served through the Illinois Odyssey portal on Sunday, January 11, 2026. And then my certificate of service and signing it. And then I also had it verified with you as my notary. And then I literally taped a copy of my USPS receipt and the tracking information, and then hand wrote on it which tracking number was which, and I e-filed that. Now, it was weird because it was sitting not accepted all week, and I was getting a little concerned as to why it was just sitting and not being accepted.
It wasn't all week. It was literally for like maybe a day.
No, it sat for 3 days. And Friday afternoon, I finally called them when I got off of work, and I'm why is it not being accepted? And then the clerk said, oh, we were waiting to actually physically receive it, and then we'd file the correspondence. We didn't want to accept the correspondence and then you not send it to us. I'm like, okay, awesome. So she's like, we verified we got your package today. We're going to go ahead and accept that correspondence. And of course, within 10 minutes, it was accepted and then served off to Justin.
And then you turn to me and you're like, oh my God, it's crazy. They're following the rules.
Right. So then I also, just from my records, I printed the USPS tracking off the website for Justin.
For proof of delivery.
Right, proof of delivery. So Justin received physically in his mailbox my appellant brief on my birthday, Thursday, January 15th. And then the appellant court, as they said, received it on Friday the 16th at 10:44 a.m. So that coincides with them saying they received it on Friday. So that's where we're at with my appellant brief now.
Yes.
Now it's the ball is in my ex-husband's court. He has to do the appellee brief. And then if he does that, I have to reply with my reply brief. And then after that, it goes in front of the 3 justices, and then they do their part.
Unfortunately, with appellate court, a lot of it is a waiting game.
Yep.
To go through the steps.
But I do want to say I also did request an oral argument because Justin is pro se and I'm pro se. I know my case inside out. And Justin Serlick has been having his mommy and daddy, Mary and Ira Serlick, running everything for him. So I don't even think he can properly argue the situation because he hasn't shown up to a single one of the Illinois Circuit 19 hearings. It was just also his attorney, Will Traberis. So I don't even know if Justin knows what the hell is going on with Illinois right now.
But he's
non-existent.
He's been served every possible way.
E-filed direct email and according to USPS, physically. So there's no other way to serve them other than physically hand them a copy of it, which I'm not doing. I'm not going anywhere near my abuser. But, you know, that's where we're at with it. And I honestly, truly, for my personality and for my gift of writing and for my complex PTSD, I love appellant court. And honestly, when I get my certified paralegal, I really want to help people with their appellant cases because I am good at this. Once I know the rules, I'm pretty damn good at it. It doesn't involve me sitting in a courtroom, being silenced, having to sit next to my abuser and rapist. It doesn't require me having to be bullied and harassed by these judges. It doesn't require me to do anything but what I'm good at. Writing out the facts and the arguments and putting the case law and the statutes together to argue my case. And I'm good at that. So I truly enjoy this.
So, Tom, to answer your question, I see you put up 1983.
42
question mark.
USC.
Yes, that was the year I was born.
42 USC, 1983, 1985, and 1986 is coming this year.
That is the 1983 is the basis of the civil rights, federal civil rights claim against the bad actors who have been just flagrantly violating
my children's rights.
It's not even just yours, just parents across the nation and family court.
Everyone. The moment you recognize that they're violating your inalienable rights as a U.S. citizen, start building your federal case. I've literally been building my federal case since this began 6 years ago, and now I'm pulling the trigger this year.
For anybody who might have just recently been pulled into family court or a child protective services situation, your rights to be a parent and be the parent of your children is actually a foundational constitutional right that the Supreme Court has said this is one of the top, civil rights in our Constitution Amendment for parents. And, up until now, up until recently, family courts have just been able to get by. As we found out, they are closed loop systems with no oversight, and they've got all their little tricks that have kept them out of the public eye and out of oversight, and those days are coming to an end. They really are. The situation has just gotten so horrendous. When I first met you and you started telling, you were slow walking the details on your case.
I was scared to explain it because it's
understandable.
It's mind blowing.
But as you were starting to explain some of the stuff that happened, I'm sitting there, complete novice, saying, "Well, there's no way that happens. There's got to be something else. There's got to be something."
And why did you think that?
Because we're all raised that the courts do the right thing.
We're taught to trust our government from a very young age.
Really the past, little over the past year and a half has just been eye-opening as you and me have both been connecting with people across the country and realizing, that your situation wasn't unique, that there's other people locally, there's other people across the nation that have almost identical stories to you. And then
a lot of us,
that was
stories.
When you realized your story was not unique, that's sort of when this podcast started, because that you were like, okay, I don't have a unique story. Now's I have to tell my story. I
have my entire life between my grandfather, between Girl Scouts, between 4-H, student government. I was very involved in middle school and high school. I have always been taught to use my voice and to be the voice of change. And I always thought that my passion for using my voice to be the voice of change was to protect the planet. To fight for environmental protections, to fight for freshwater resources. My whole life has always been about wanting to protect the planet and, take care of the only place we have to call home, which is planet Earth. And then in 2020, I was thrusted into this family court nightmare, and I blindly trusted attorneys, willingly took out loans, because the protective parent is always the parent that's willing to go above and beyond to fight. So we take out loans, we do title loans, personal loans, car loans. I mean,
we were just talking about this the other day. You mentioned one of your attorneys made a comment as we were walking out of his office one day, and his comment was, "We'll see just how good of a mother you are."
Yeah.
And what did you take that? You didn't take that necessarily at the time, but we've realized what he was getting to. What was he getting to?
When he first said that to me, this would have been early October of 2024. He was getting us ready for this BS contempt hearing. And that day, he had asked us for another like $15,000 to re-up our retainer with him.
Yeah, we'd already paid close to $20,000.
And this is Rick
and
Brown.
Nothing had been done.
Rick Brown in Daytona, Florida. And he made a comment as we're walking out that day. I guess we'll find out how good of a mother you are. And at the time, I thought he meant as far as like doing well in the contempt hearing to fight the contempt hearing. And then a week later, he randomly withdrew from my case 24 hours before Hurricane Milton hit and 10 days before that contempt hearing that now I know was a setup. He was dipping out because he drained us and bled us of every cent we had.
Yeah, he got all the money, because one of the last conversations we had with him was about money and how we were sort of starting to have to put things onto credit cards. And then the very next thing he's like, "Okay, I'm out." You guys basically he was like, "Okay, you guys don't have any money. See ya."
So now looking back, I've realized that comment about "we'll see how good of a mother you are" was really to see if I was going to take out another loan to keep paying him to delay all my hearings.
And unfortunately,
instead he dropped out 24 hours before Milton, left us in a state of panic because now we're preparing for the hurricane.
And
a contempt hearing 10 days, 9 days after the hurricane hits. So he served me up on a silver platter, and I've been fighting all of 2025 and now into 2026 to undo what he did.
That same sort of narrative that you were just sort of pointing out we see it so many times in family court stories across the country where
they're just bleeding up us
literally,
all of our
the
money.
system is designed when one parent reports abuse, whether to themselves or to the children, the system then says, well, we're not going to decide whether there was or wasn't abuse. We're just going to give the kids to the parent you're saying is abusive. Because if you are a good parent, you're going to spend every last dime to get them back.
Do whatever you can to keep fighting. And that's what these attorneys and judges are hoping for.
And it's disgusting.
That's why they delay, kick the can down the road, continue. Yeah. It is all the same playbook. Wow. So I went through technically four attorneys, because for my Illinois case, I had attorney Thomas Hunter and Oren Grappe of Barrington, Illinois. So there's two attorneys.
You actually started with Gravel.
Well, Gravel was at the very beginning. He was my attorney for a whopping month before he dipped out.
Because he doesn't handle DCF.
Dennis Gravel made $1,000 off of me. Then it moved to Thomas Hunter and Oren Grappe, who are friends of Gravel. That's how I found out about him. Gravel referred me to them. They did absolutely nothing except, Your Honor, I have COVID. I need a medical continuance. Your Honor, I wasn't prepared for this. He literally continued my case 3 times. And then all of a sudden, my kids are shipped to Florida.
They mailed you copies of their emails just so they could bill you for printing and mailing the emails.
Yep. The billing
Facts.
and it's all in my invoicing. So Thomas Hunter and Oren Grappe racked up $45,000 in my invoice with them. So there is $46,000 right there in just Illinois. Then I get to Florida. I hire Mary Jane Nettles. That was the $3,000 retainer. She did nothing except ex parte communicate with a judge that had nothing to do with my case and stalled out my case. So she is absolutely going to be a defendant in my U.S. District Court complaints. And then I terminated her and hired Rick Brown in Daytona. So Mary Jane Nettles is in New Smyrna Beach, Florida. in Volusia County.
But all part of District 7.
And Circuit 7.
Circuit 7.
And then I fired her and hired Rick Brown of Daytona, Florida. And he's the one that kicked the can down the road and then served me up on a silver platter. So in total, I have spent over $66,000 between 5 attorneys and gotten absolutely nowhere. As a pro se litigant, I have not only gotten a ton of stuff filed on the record in Florida Circuit 7 and Illinois Circuit 19.
You've also actually uncovered more information through Freedom of Information requests.
Public records requests, etc., which none of my attorneys did because now I know that they were all in on this BS the whole time.
Well, it's because the attorneys took all your money, so there was no more money for them to take from you to get private investigators.
They literally bled me dry and then dipped out to serve me up to Justin Serlick's attorney. Now
we're coming up. We're over an hour now. Originally, we were hoping to get into some of the details on your appellate brief. I think that we'll definitely need to get into the details on another episode. Because there's
the documents. If you are interested to see how I wrote this and how adamant I was about calling out every single state actor by name,
and this is all public record now.
I'm building a federal
public docket,
a federal complaint, and all of these people are going to be defendants. So having them listed by name in my appellant brief, the appellant brief itself is a piece of evidence in my federal lawsuit. I'm getting ready to start writing and filing this year in 2026. So that's my main objective in this new year is to first, get my U.S. District Court complaint filed in Orlando for my 42 U.S.C. 1983, 85, and 86. And I'm also considering filing RICO. I have been following attorney Matt Grant's RICO case in St. Louis, Missouri closely.
Which some of the details behind that are just like mind-blowing. That the family court actors were so...
The fact that they're messing with a
25-year experience federal litigator,
a well-decorated attorney who works in federal court,
who was pulled into a family court issue with his family, and they tried to pull, or they did pull, all their normal family court bullshit games. Sorry about that. and as if he was just going to roll over and take it, and some of the stuff he's put out there is just wild. So I recommend people follow him.
Yeah, his
get
RICO,
an idea. Like the times are definitely changing.
His RICO in 1983 complaint that he filed locally into U.S. District Court in St. Louis, Missouri area is essentially a roadmap for us pro se litigants to study and use. So I, the other day, made a Facebook post posting his entire case on the website, and then I posted the link directly to his current, it's the first amended, because he had to amend it first time for something. He now has a second amendment it's pending to be approved and processed into the federal case, but it is there, and I do have a copy of it that I am now studying for my own RICO and 42 USC 1983, 85, and 86. So, he's an attorney. I trust him. He's also got attorneys he's hired to help him with that. So there's multiple attorneys working on that. So as a pro se litigant, that is gold for us. It's public record. It's available for all of us to gain access to. So absolutely follow attorney Matt Grant, attorney Christine Miller, and attorney Hugh Barrow in the Judgmental podcast based out of Louisville, Kentucky, has had him on a second time just this past week where he goes into more details about it, and I'm sure they're going to have him back on again. It's literally a powwow of 3 attorneys all whistleblowing in a podcast episode together, and it's brilliant. Yeah. So definitely check out their podcast. It is great hearing 2 attorneys wanting to see this system have real reform changes.
And speaking of podcasts, if you have listened to us up to now, we're going to ask you, this is very important, please, if you're watching us on YouTube, please hit the thumbs up button and subscribe to our channel as well. Hit the bell notification. You'll be notified when we do post the recordings of our Facebook lives and other things that Heather posts related to her case. But we're really trying to just spread the word, get the word out. I mean, Heather, for better or worse, we're in the position where she has nothing left to lose in court. She can only,
can only go up from here.
They've already taken her kids, so she's
from
fighting
here
to get the kids back. But
not only that, my children need help.
The story needs to get out there.
Yeah, the whole first episode of season 2, which my seasons are broken up by the year. So 2025 was season 1, 2026 is season 2. So episode 1 was all about my true concerns for my daughter Bianca Serlick, who is 14, and the evident abuse and neglect that she's dealing with. So, I mean, my ultimate goal in all of this is to get my children some much needed help.
Yeah.
Obviously, I want to be part of their lives. Obviously, 6 years have now been stolen from all of us because of Justin, Mary, and Ira Serlick and their very manipulative and controlling ways of going about this to ultimately abuse me.
Yeah, which we'll get into on that's its own podcast episode.
But
we got some new information.
Yeah, so I definitely need to get my children some help in any way I can. And right now, this is the only way I can. So this is what I'm going to do.
Yeah, you've tried making every other report, talking to everybody you could think of. And this is sort of the last thing, is putting your story out there for the world to see. So that's what we're doing. So here's our ask. Again, if you're watching on YouTube, please hit the thumbs up, subscribe, hit the bell notification. If you're listening on Spotify or any other podcast platform, like and subscribe to the podcast itself. These are important to help get the story out there. If you know people who are in the family court system, please share our podcast with them so that they know they're not alone, that there's other people.
What does my shirt say, by the way?
Liberty, justice, freedom.
Read, white, and blue. So this past week in my school district as a public school teacher was Literacy Week. And this was a shirt that my district sent out and said, hey, teachers, if you're wanting to wear something for Literacy Week, here's a shirt. And I saw it and I'm like, oh, this is so perfect. It literally is a book, 3 books on top of each other, Liberty, Justice, and Freedom, and then read, white, and blue for Literacy Week. So I thought that was an appropriate shirt to wear for this conversation.
Yeah. So again, we were just putting this information out there. This is educational. We want to share our experience. Hopefully, some of our experience will make other people's experiences better. Of course, we wish nobody had to be dealing with this and going through the family court system, which is just absolutely atrocious. But if we can help anybody out, that's our goal. If you click in the check out the description. We're going to have links to all of the documents Heather referenced. Heather, there's also going to be a link for people to sign up to be guests on our other podcasts. So you've got the Disrupt the Corrupt podcast. And what do you do on that podcast?
And that I'm going to be having other victims that are in my situation or have been in my situation on as guests, very similar to Marianne Petrie's Slam the Gavel, where you tell your story to the world on that podcast.
And then I've got the Support Isn't Silent podcast, which is focused on telling the stories of people like me that you're thrust into a family court situation, but it may not be, you are not one of the people in the court necessarily, but your partner is, or your
sister, brother.
Yeah.
It's for any family or partners of someone that's going through what I'm going through. Because
the family court doesn't just affect the people whose name appears on the case.
Yeah, it absolutely affects you too. It
So
oozes into every aspect of your personal life because you're living with me and seeing the hell that these courts are putting my children and I through. And, it's affecting your emotional state, your mental state. It's taking time away from your job and, your personal life. So it absolutely affects you. You are absolutely a victim of this as well.
Yeah. So,
and I do want to say, I made a post last night. Episode 3 is going to be later this week, and it is going to be us sharing our screen and exposing someone who claims to be an advocate in these movements, but in reality, they are stalking and harassing
and very clearly just collecting,
screenshotting people's social media, creating folders,
and selectively saving information to create a false narrative.
Yeah.
That's the best way I can describe it without
person
cursing.
is portraying themselves as a family court advocate who is trying to help victims, but in reality, they are absolutely stalking the victims, harassing the victims, and abusing the victims.
Yeah, and we
and
got
it's
some
time
information today
to expose that person as well.
Yeah, we got some information today that was pretty disturbing that somebody affiliated with the person we're talking to. We have screenshots of text messages where he actually was encouraging a family court victim to jump off a bridge and kill themselves. And unfortunately, it appears that is exactly what happened.
Yeah. We have several advocates in this national movement that are dangerous. They are not advocates at all.
So we were sent a link to a number of files, and we're gonna show it. We're gonna put the stuff up on the, and we're gonna dissect some of it,
and we're gonna have fun with it. Some of it is very humorous,
hilarious, and some of it is. I mean, it's you have to laugh at some of it because it's such a serious thing, but some of it is just off the wall.
So Pete, if I had someone suing me in federal court, where could one find that case? Because it's public record.
Oh, that's super easy. Because it's public record, there's actually a whole system. It's called Pacer. It's online. You can Google federal court Pacer, and it pulls it up. You can just sign up, create your account. You can actually search any federal case.
Like how I got Matt Grant's RICO case that's in federal court right now. I literally saved a copy of it to my computer so I can study it and build mine off of his.
So
everything is public record. There is.
You mean you can't just say something in an email and poof, it's real?
Yeah, there is in the documents I was provided. And I'll give you a lead into our next episode, where my ex-mother-in-law emailed these advocates, quote unquote, claiming to have already sued me in federal court, won millions of dollars, and they're waiting for the settlement.
They're going to be waiting an awfully long fucking time.
What the heck?
I need to get better at hitting that button.
So, needless to say, we're going to show that email. We're going to show the email that Mary Serlick sent it to. We're going to show the person responding back to her. There was some of the other stuff. There was some stuff that just jumped out like, oh, wait a second, something's not right here. And you look at it and then you realize
they literally
cropped.
They literally they created screenshots by cutting and pasting. And
multiple different of my posts, and where it doesn't, it's like two different scenarios put into one post.
They put them together, and one of the biggest red flags that something's not right is one of them. Literally, it had. If you have an Android phone, you know the navigation bars at the bottom. It's what is it on yours is right there. On the bottom gray bar, you have 3 lines, sort of a rounded square, and then a left arrow caret button. Right. So if you have that in the same screenshot, but the very top is the Apple iOS top screen with the clock and the icon. Something's not right.
I don't use Apple, but I know someone that does.
So
Laura Stiles uses Apple.
But anyways, we're gonna show some of that stuff and
so apparently I've already gone through federal court. I have been sued by the Serlicks, and they have won millions of dollars.
I mean, I read that email, and I was just
not a millionaire. Where are they winning that millions of dollars?
I was dumbfounded. But we're gonna show the world. We're gonna put it out there.
Yeah, we're gonna have fun with it. So stay tuned for episode 3. That we're going to be exposing some of these quote unquote supposed advocates across the nation that are harming court victims instead of helping them.
All right, everybody. On that note, we're going to call it a night. Enjoy your weekend. We appreciate everybody that stuck around and watched. This is one of our most watched lives while we were live. Looks like we at one point had nearing the double digits for actually a good part of this video while we're live.
We appreciate all of you.
Probably the most comments we've ever received live during a video.
That's good. That's good. We're here to educate.
Folks who made some comments, Tom, Kelly, Phil, thank you very much. We appreciate it. Help spread the word. Share this with other people you might know that might benefit from our information.
And remember, we're not attorneys. We are not giving legal advice.
We're just sharing our experience.
This is for educational purposes only. I am an educator, so I'm going to educate. On that note, I hope you guys have a great rest of your weekend and a great next week. We'll see you in episode 3 where we expose some of these fake advocates across the nation. Here's some good music to go out on. This is a customized song we had created for this podcast. Have a great night, everyone. They bury the truth, they cut us apart. Corruption thrives where the silence stays. But we're lighting a fire to burn down the maze. We are the voice for the voiceless. We are the voice for the voiceless. This is the Justice for the Serlick Children podcast.